Okay, this is a meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. Calling the roll, Hartston.
Here.
And we've been informed that Ms. Sarouche is not available today. So we can go ahead and get started. I'll see if there's anybody. Is there anyone who, of the attendees that wants to make public comment? If so, please raise your hand using in Zoom. I don't see any raised hands, so you go ahead.
Okay. Do you want to introduce Ken Brady? Or Ken, introduce yourself.
Sure. Hi. For those of you I haven't met, I'm Ken Holloway. Along with Brady, I'm in the Office of General Counsel, and myself and Caroline Holmes do the majority of the work with the admissions department. So at various times, Caroline and/or I will be listening in just to start getting our feet wet, informing ourselves about what is going on, so we can start to take a look over the next couple of months to see if there are any places where we can contribute with our expertise a little bit.
So Amos, Ken is part of a large strike team that the Office of General Counsel has put together to help tackle the many aspects of the rules and statutory work that aren't necessarily encompassed in what we've been doing with Greg and Randy and Andrew and team.
Perfect.
Okay, so Greg, I think I'm gonna turn it over to you. You sent out I sent out a memo or sort of an update in preparation for this meeting.
Mm-hmm. Yeah, so I think, as I alluded to in the memo, we had left off on that list of policy topics. And so I guess I want to put it back to you all. Is it something that we want to pick up at this point? Or one thing I know, Amos, that I wanted to address, since you had proposed some rules pattern on the admissions to practice rules from Washington State, number 28, Rule 28. I kind of, in that memo, tried to do a walkthrough of how I envision incorporating some of those concepts in either the rules of professional conduct or in rules of court or some other set of enabling rules that will set the framework for the paraprofessional program. And then wanted to get your feedback, because as you could probably tell from the memo, a number of the provisions that you included have parallel provisions within the rules of professional conduct for lawyers. And of course, all the rules of professional conduct are enforceable by discipline. So that's a fundamental question. To the extent, for instance, a paraprofessional doesn't comply with the informed consent rule, are we envisioning that to be a disciplinable offense, or is there some other consequence that we want to impose? And that will really inform where that provision should lie. And what set of rules. So we could go through that and kind of walk through that, or we could pick up the policy topic discussion, because I think we left off on discussing the extent to which paraprofessionals can combine in firms with each other, and the extent to which they can combine with lawyers, and the implications for that in the rules of professional conduct.
So I'm happy doing either. I think probably if I had my preference, especially with Fariba not able to join us right now, is going over the memo that you did and the draft rules, because Fariba and I have talked about those pretty in detail. And I think we could probably make a lot of progress there. On the policy issues that we haven't yet discussed, I really don't know where Fariba is on those. Right. Although we did get a good start over the last couple meetings. So, you know, I'm happy to go through sort of where I would propose. Your memo and the draft rules, obviously a lot of work. So thank you for doing that. And I think it's it really is helpful, I think. You know, I have a couple of questions and comments, but overall, I think it's you know, huge leaps forward in what we're trying to do. So thank you for doing that. And I think it might be helpful to just go through that. Okay. If I can, though, I think, so your memo started with the fees. I don't know if we should start with the fees is my one thing, because I think that's still a big unknown. And maybe the full working group is going to discuss that. And that's a little bit, again, I'm happy to discuss it, but I think where you went through the informed consent and the written agreement and other of the related rules, I think we could make a lot of progress.
Okay, that makes sense. Okay, so let's see, let me pull up my memo here.
I put it up here
Oh,
too.
great. Okay. So if we slide down past the fee section, I'll do the same. I think the next thing we talked about the written agreement. Okay. So let's see. So as I say, I recommend that actually what might be more helpful, Leah, is if we pull up Amos's draft rule so that we can look at that. He had a set of rules that he had sent out to us early on.
Okay, Amos, do you have those handy? Because that will take me a little while to find.
They are attachments to our final report, the attachment A to the final report.
Okay.
Oh, yeah, everything except for the fees. The fees, we didn't do that.
Posted for the meeting.
I should be able to pull that up pretty quickly.
Okay.
Okay.
I think the only ones we did not attach are the fees, which we felt like we weren't ready to do, and the advertisement, the things based on rule of professional conduct 7.
Okay, I'm going to share this.
Okay, that's the informed consent. I think there's the written agreement. Oh, yep, that right there.
Is this what you want? Okay.
Yeah, that's what I start discussing here in the memo under B. And I'm recommending that first paragraph. So the first paragraph must personally perform all authorized services for the client and may not delegate these to a non-licensed person or device. So my suggestion here, so we're going to have a parallel rule to the lawyer rule 5.5 for UPL. And my concern, as I alluded to in the memo, is that we just say authorized services rather than authorized legal services.
I'm sorry, whoever's typing, could you put your sound on mute if you don't mind? Thanks. Go ahead.
It's just to specify what we're really trying to restrict is the paraprofessional delegating the services that we would consider to be legal services, the practice of law, to anyone who's unlicensed. And that restriction actually is covered under the UPL rule, under the black letter rule. But I think this is and so I think this could be a helpful comment to that rule. And I would probably tag that for, we haven't, just back to a point of, the process that we're going under here. We actually just put aside the comments, because comments to these rules, it can really bog us down. I think once we solidify the black letter rules that we want to move forward with, we can revisit the comments and decide which ones from the lawyer rules make sense, with obviously some conforming changes for the rules for the paraprofessionals, and then what additional comments we might find to be helpful. And again, the comments are providing interpretive guidance, we're hoping to ensure compliance here, so not just setting standards for discipline. And I think this might be a helpful area where we could say that, because to the extent of delegating the performance of legal services to a non-licensed person or device, that would violate 5.5A. And we can point that out, I think, through the comments. So that's my suggestion there. I don't know if you have any feedback on that.
Yeah, I think that sounds great. I mean, I think you have the finger on the pulse of sort of what goes in comments and what goes in black letter. And I think that makes sense to track what the California Supreme Court just recently advised and approved with respect to the lawyers' rules. With one caveat, and because there's a few places where you recommend putting in comments, and I think my concern is the way Washington State did it. All the rules are together and are clear and provide clear instructions and guidance for triple LTs on what they can and can't do. And my concern is by spreading these issues throughout the rules and by putting some in comments and some in rules, what you might lose is the clarity that comes with just here's the list of what you can and can't do. Here's the rules that apply to you. Now, obviously, that can be done in ethics training, and there's going to need to be that kind of training. But that's my concern is when we pull these apart and spread them out and put some in comments, we kind of lose that clarity, which I think is kind of a benefit of the way Washington State did it.
Yeah, I understand that point. I actually found that because Washington State is actually, they also have a set of rules of professional conduct for the triple LTs that cover a lot of these same topics. The fact that they have another set of rules that covers them, but in slightly different language, I actually found that more confusing. But I understand what you're saying in that, and this may be, I think, something that we could cover through advisories and ethics opinions, where we set forth in a very clean list. These are the absolute must do the minute you're doing intake with a potential client or signing someone on to representation with, and then crosswalk to the rules so they can be clear about where they can find this information in the rules of professional conduct. But my concern with Washington is that they had two sets of rules covering the same topics.
Right. And so I agree. And it might be a training that we put together as the first order of business, which is, a clear training on what a paraprofessional is allowed to do and not. Obviously, if that's clear from the rules for any person reading it, that would be my preference. But if it's not, maybe we can put together a cheat sheet.
Absolutely. And I think the first training they're going to get is when they actually try to fulfill their licensing requirements too, and have to take that professional responsibility course as well. But yeah, I'm always a little worried about having slightly different language trying to cover the same thing, because then you're asking for litigation and a lot of challenges as to what exactly was meant and whether it means the same thing in both places.
So I agree for this number one point here on the screen, that can go in comment, and I defer to you if that goes to comment to rule 5.5. That sounds like it makes sense. Of course, that makes it disjointed with these other ideas because it's somewhere else, but I agree.
Well, and this is when we get to the comments, this is one of the things that we can achieve through comments is a really helpful cross-referencing amongst the rules.
Right.
So that, and we did that with the lawyer rules. I think it's been pretty successful. One of the things, I'll just give you some backdrop. One of the, you may or may not know, but the lawyer rules underwent multiple revisions over decades. And the court sent back a full set of rules back. I think when I first started with the court, it was one of the things I was brought in to help shepherd through. Partly because the comments, especially if you look at the ABA model rule comments, they go on for pages and pages and pages. So the comments, which are meant to provide guidance and clarity, actually were making things a little bit more murky. And so we wanted to have a lean set of comments, but with the objective of achieving exactly what you're talking about, is trying to stitch together these rules so that it makes sense and you're not having to search around and be surprised by the effect of one rule on another. So that's going to be the heavy lifting that we're going to be doing once we start addressing the comments as well.
Right.
Can I step back for a moment, Greg, and just ask a question? So one of the policy issues that's being made now is putting this in the rules, right? Which makes it failure to comply a disciplinable offense. And that's different than the rules for attorneys, right?
No, let's see, we're talking about UPL now, and the consequences of a UPL violation are
Mm.
multiple.
Okay, no. I'm not talking about UPL. I'm talking about the disclosures and what needs to be contained in the written agreement.
Right.
Yeah, there's a business and professions code for lawyers.
Right. In terms of a written agreement, a retention agreement, yes, that's correct. So it's in the business and professions code for lawyers right now because the legislature has decided to regulate in this area and require lawyers in any representation in which it's reasonably understood that the legal services are going to, the charge for legal services is going to exceed $1,000 or more, exceed $1,000. There has to be a written agreement, and there's standards that in the statute itself that requirements for the written agreement. And the failure to comply with that, the consequence is the contract is void at the election of the client. So the client can choose, can avoid enforcement of that contract. That's through case law, of course. The lawyer still may seek recovery under a quantum merit theory based on the services provided, but the contract itself would be void at the behest of the client. That doesn't necessarily mean that would result in a disciplinable offense. It would have to be additional conduct that would violate the existing rules of professional conduct. So, for instance, if the fee that was being charged was considered unconscionable, or there was some overreaching or fraud by the attorney in obtaining the contract or in the terms of the contract, the lawyer may be subject to discipline under the rules of professional conduct, if that helps.
Okay, so I'm asking because I think if we are taking a position that generally we're starting from our attorney framework or the paradigm that's set up for attorneys, I'm wondering, like, when we deviate from that, does there need to be a rationale? So, Amos, like, why should this be a disciplinable offense for a paraprofessional? And excuse me if I'm not using all the exact right language, but why should it be one way for the paraprofessional, not that way for an attorney?
Yeah, so I think that's a great question. And I would also ask it slightly differently, or it raises another question, which is, should there be additional remedies, right? So by putting it here, it's potentially a disciplinary issue, but should it be a voidable contract? Should there be a cause of action? Right now, it's kind of muddled the way it works for attorneys in California, just because of the historical way malpractice cases are really independent, but they often rely on the rules of professional conduct. I think I saw in these draft rules a specific statement that these disciplinary rules are not intended to, raise liability in a malpractice action. And so I think we just need to be precise. Is the point. Is this for discipline? Are there other remedies potentially? And if we want there to be, how would we even do that if we wanted to?
Right.
It's fair.
So just, okay. It does say that in the rules. Obviously, we know the rules of professional conduct do establish certain standards that are used in malpractice actions. So, yes. And that will probably, I would imagine that could be the case in terms of the standard of care that a paraprofessional needs to abide by. And I imagine in case like that will develop. But the rules themselves are not, so for instance, the Office of Chief Trial Counsel can't seek additional remedies beyond discipline for violation of these standards. And so I think that's really what that is intending. What we've covered so far, though, paragraph 1, I think is just an example of a violation of Rule 5.5 or the equivalent of 5.5.
Exactly.
But now if we move to my next section that I'm covering here, I think this gets to more of what you're talking about, Leah, which is having a separate rule. What I'm recommending is that we combine your informed consent rule along with the provisions of the written agreement rule into a new rule. And to the extent that someone violates this type of rule, it could lead to discipline. We're diverging from the template that we have for attorneys at this point. And I think to your point, Leah, we have to probably have a rationale for why we're imposing a higher bar for paraprofessionals in this regard as compared to attorneys.
And again, the remedies issue is also critical, because if a paraprofessional does not provide informed consent, does not get informed consent, or does not provide a written agreement that follow these rules, the way this is structured, if you're putting it in the rules of professional conduct, that's subject to discipline, but there's no other remedies like potentially voiding the contract or getting your money back, or any other remedies.
Right. And if we want to do that, if we want to provide that remedy, we would have to do it either through legislation or a rule of court, perhaps. And this is where we get into this whole territory of what additional rules are needed, because I question whether or not we could provide that type of remedy under the rules of professional conduct. It's not really what the rules are intended to do.
Yeah. And the reason I raise that is I think it's also an answer to the first question, which is this is our best attempt to provide the appropriate regulation without legislate. I mean, again, we might suggest some legislation, but this is sort of having rules of professional conduct that set the standards.
Mm-hmm.
In the absence of being able to, have a new revised business and professions code to provide these same things and additional remedies. I think this is sort of the best we can do. I that's at least my sense, but I'm open to, recommending that we do have new rules, new legislation to cover some of these topics as well.
Mm-hmm. Okay. So I drafted a new rule 1.5.2 that tried to incorporate a lot of the provisions, both from this written agreement rule as well as the informed consent rule. And my thinking here was these are obligations that a paraprofessional needs to discharge at the commencement of representation, even before the commencement of representation, actually, because they need to do an assessment, provide information to the prospective client, get their informed consent on it before they enter into the relationship. And so containing it within one rule, and again, there isn't a counterpart within the rules of professional conduct for lawyers, but I think that 1.5.2 is the right place to place it, because 1.5 covers fees and services, and 1.5.1, what's the title of that one? Let's see. Yeah, 1.5.1 is fee divisions, which is another topic that we're going to have to cover later. So it seems to me that that might be the right place to put a rule that covers this information, with the understanding that violations of that rule will result in discipline.
That makes sense to me. I in my mind, I think of informed consent as coming time-wise before the written agreement. So at least consider if informed consent should be A and written agreement should be B. But I have no problem with the way you propose putting this in 1.5.2 and the language. Obviously, there's some things to discuss, but I think that this is great.
Right. And yeah, as you see, I borrowed some of the language just to be consistent, some of the language that is used in the Business and Profession Code 6148 for lawyers, just for consistency in terms of interpretation.
Right.
And then so A is prior to performances of legal services, and B is also, I see what you're saying. So, well, I mean, okay, so that's one of the things that I think that we need to talk about, is whether or not we're envisioning this as two separate writings that need to be obtained from the paraprofessional. And if so, what's contained in each writing?
Yeah, and this is where we may need FREBA, but at least my conception, and we've discussed this before, is these are two separate things. I think we're coming to the concern of, is this repetitive from the place that the written agreement is clearly something we want with disclosures, and informed consent is a separate thing that we want. And I think we just decided, oh, that should be in writing too, but it wasn't supposed to be the same or replace the written agreement. So at least in my mind right now, I'm open to discussions and comments on this. It's really the informed consent in writing is just confirming that there is informed consent, and maybe there's a form for that. Might be better if there's a form for that.
Yeah.
But that's really separate than the retention agreement.
Right. To the extent, I mean, as you saw some of my notes, to the extent we can provide a form, especially when there's a disclosure of risks of engaging a paraprofessional as opposed to a lawyer. I mean, I don't know if all paraprofessionals are going to be in a position to, I mean, it may be a subjective evaluation. There are risks on both sides, there's benefits on both sides too. So do you want to just go through rule 1.5.2 and just kind of walk through what I did? And I, as you saw, I provided alternative language from B&P code 6148, and you can let us know which formulation you prefer.
Yeah, that's
Did
okay.
you
And
wanna-
as you know, I think
Like,
Share that, or
If you let me,
I'm just wondering if,
I can pull it
what's
up.
that?
If you let me
Yeah.
screen share, I can pull it up.
Yeah,
Yeah, and
I
Greg,
took down my
I
screen
think-
share.
Greg, I think as you know, and maybe commented on, the written agreement was really tracking one of the Washington state's rules, and I think they did a pretty good job. But I agree with you that if there's other language that we should parallel that already exists in California that applies to lawyers, that would be the preference. So I thank you for doing that.
Can I just ask a question?
Sure.
Why does the written agreement, why do the written agreement and informed consent need to be two different documents?
Well, I think that's, again, a policy decision that we're discussing, but I just explained how we arrived at them for two very different purposes.
Mhm.
And combining them effectively, in my opinion, eliminates the informed consent requirement. The writing, for me, the informed consent requirement doesn't necessarily need to be in writing. There just needs to be informed consent. That was something that the ADLS working group also suggested that we consider, and we did consider it. And I think Fariba and I agreed there should be an informed consent requirement. That is separate from the written agreement requirement. So that's sort of the history of how we got here. But I agree, we don't necessarily need to be repetitive and make it more difficult. We want to streamline it. But the idea is a written agreement and an informed consent requirement are two different requirements that come from two different places.
Right. We tend to, in California, when we went through the whole rules of professional conduct, be a little bit more strict about requiring informed consent to be in writing in areas in which the ABA model rules just requires disclosure and verbal consent. I think it's actually, from an evidentiary standpoint, it makes it makes proving a violation a lot easier, and also for the paraprofessional or the lawyer, also makes it a lot easier to respond to potential investigations or charges if they have a written document. So we also just felt it was more public, it was a greater level of public protection. But in some instances, I mean, a writing is defined under the consistent with the evidence code. So sometimes informed consent can be obtained through an email confirmation or something like that. So the extent that we want them to enter into a written agreement that has particular provisions, and we also want to provide a form, an approved form for that, it may make sense to combine the two.
Yeah, I agree with all of the benefits of having it in writing. I think that's a much better practice and provided more protection both for potential clients and paraprofessionals. So I again, I don't know that it necessarily is mandatory to be in writing, but I certainly think that's a best practice, and I'd be supportive of having it in writing. But I do think the written agreement of defining what legal tasks you're going to perform and what the costs are going to be, and sort of following the template of all the rules. That was really intended as a writing requirement for the agreement, rather than the separate informed consent discussion, which is make sure you know what the risks are and make sure. And so I'm concerned that if we combine them, we're really undermining and missing out on the separate informed consent discussion and requirement. And so I think I'd prefer to have a no writing requirement and require informed consent than eliminating a separate informed consent requirement.
Okay. Okay, so under A1, I just provided the alternative language from the B&P code. I think they're pretty similar. B&P code just requires lawyers to have an explanation of the general nature of the legal services to be provided to the client.
Yeah, I like following the B&P code as well.
Okay, and then you'll see I highlighted may not representing a client in court. I guess we're going to have to wait until we decide whether or not that's going to be a restriction. And actually, it brings up in my mind whether or not, and I think we need to revisit this when we have a clear sense of the authorized activities for each of the different types of paraprofessionals, because there may be, I don't know where the group is going to go, but it may be in certain, as Steve Hamilton likes to say, endorsements, an endorsement for family law. There may be things that are permissible where they're not permissible in another authorized area of practice. So
Right.
We may have to generalize this a bit more just to say that that they disclose. Obviously, it's not a lawyer. That's going to be true in every case. And then in terms of the actual things that the paraprofessional can and cannot do, it may be dependent upon the services that are being provided.
So do you mind if I make a comment on that? I 100% agree. I think in the draft that I circulated, or Fariba and I circulated, that other document, there was actually a placeholder here in 2C that, the main idea was it should be clear what a paraprofessional can and can't do. Obviously, that hasn't been developed yet. So it's a chicken and egg problem. We can't really state what that is yet. But the idea is, for the purposes of the written disclosures or informed consent, it should be clear what the paraprofessional can and can't do. So we put a placeholder. I think in your memo or in your draft, you suggested that that be moved to comments. But again, I think the issue is, I think our proposal is that the rules be clear and the disclosure be clear what a paraprofessional can and can't do. And it's hard to, I agree with you, it's hard to do that right now because it hasn't yet been decided.
The second part of that provision, I think I make a comment later about this, but I wonder, because it says that this particular disclosure needs to be on the first page in a certain type, size, font, color, sufficiently noticeable and easy to comprehend. And it just occurred to me that to the extent that we're putting all of these different requirements for the written agreement, setting them forth in a rule of professional conduct, I would imagine we want them all to be clear and conspicuous and in language that is easily understood as well. And whether or not we want to move that requirement really to the introductory portion of the rule to make clear that everything that follows, I know that you want this particular disclosure to be on the first page, but that all of these disclosures are in clear language and the certain, a lot of this language you have type, size, font, color, appearance, and location sufficiently noticeable for the client and comprehensible for them. And again, we're gonna, I think, hopefully provide some templates that they can use for that as well.
Yeah, I agree with all of that. I think for when Fariba and I discussed this, and again, I think following the Washington state model, this one was particularly important, but all of them are important. So I again would love for you and the state bar legal team to take this and run with it on what you propose. I don't know if everything gets to be on the first page in large conspicuous language, but yeah, the idea is these written disclosures need to be meaningful and not buried. And not in the wrong language. So I totally agree.
If
And
we're,
maybe,
if
go
we're
ahead.
doing this, you know, putting this level of specificity in the rule, why wouldn't we have a mandatory form that needed to be used? At least in, English and 6 common languages.
So that would cover some of written agreement, but obviously the client can, it depends on what the legal issue is and what the fees are, and there, there's obviously things to fill in.
Right.
This is
but
this
like
is the written
I-
this
I
is the
guess-
written this is the retention agreement.
But I guess I mean it could be like a mandatory cover sheet.
I think that definitely works for the informed consent. And I think that's probably a best practice. I don't know. Again, I'd be open to it, but I don't know if it
And it
makes
may
sense to have
work
a
for
mandatory
two.
retention agreement.
It may work for number 2 as well, because you're disclosing, I'm not a lawyer. I can only provide limited legal advice. These are the things I can do or cannot do. But I think you're right, Amos, when it comes to what we have here as subparagraph 2, a clear explanation of services to be performed may vary by client. The fees and costs that are anticipated may vary depending on the scope of the representation being contemplated.
But definitely we can do proposed language or language that paraprofessionals know works and would be,
Right.
advised to use.
Right, which I'm sure they'll find very helpful to have.
Yeah. Yes.
Especially when we start talking about the risks, because I'm not, as I said, I'm not sure they're all going to be fairly confident that they've covered the risks adequately to avoid discipline. And that's the tough part, is that where is the line? I would imagine we might have, to the extent that OCTC or the disciplinary authority is going to prosecute paraprofessionals because they failed to identify all the inherent risks of going with a paraprofessional. They may say, look, the rule is vague. I don't know. I thought I did. I thought I covered all the risks. And so to the extent we can provide that already in a template, and they make sure the client has it in language that they can understand, and they've read it and hopefully provide consent, then they've discharged that obligation.
Right.
Number 3, I propose the alternate form. The Washington language, identification of all fees and costs to be charged to a client for services to be performed. I guess that's the fees and costs that they anticipate will be charged based on what they understand to be the scope of representation at the initiation of representation. But things can change, especially in the family law area. And I think I prefer the 6148 language because it provides the basis for the compensation. So they understand, these are the hourly rates. If we have statutory caps on particular types of activities, these are the caps that I'm operating under. So if I end up having to do this type of work for you, you can anticipate I'll charge you this. And it's a little bit more flexible in terms of what is provided to the client. Because I in some ways, it may be more deceptive to the client if you say, this is what I'm going to be charging you. And then later on down the road, the client asks you to do more, which is within the scope of practice, but it wasn't really covered in the original agreement. Either we have to require them to enter into a new written agreement each time that happens, or be able to refer back to the schedule of costs and fees that were provided in the original agreement. So,
Yeah, I also agree. The BNP code section language is preferred. I'll note that in the informed consent section, and we might want to conform these, there is also a reasonable estimate of the total costs, which
right.
Again, I think would be helpful, and I think it's appropriate, but and again, when we're looking to conform these or to look for repetitiveness that we can and should eliminate. But yeah, I agree. Let's go with the BNP code language.
And this may be one area where we do want to be repetitive. It may be exactly the same information, but it's worth repeating because it's a very important part for the client to understand. Okay, so number 4, a statement that upon the client request, a licensed paraprofessional will provide the client any documents submitted. by the client and a copy of the client file. So this is actually an obligation that I imagine we impose on lawyers under Rule 1.4. 1.4. Well, I imagine we're going to have a counterpart for paraprofessionals as well. So what I'm suggesting is that alternate language that they provide a statement that pursuant to Rule 1.4. And here's one of those areas where we're cross-referencing rules, so they understand the obligation actually originates under 1.4, but here you have an additional obligation to tell your client that you have this ethical responsibility to provide them, keep them reasonably informed about the matter and significant developments relating to representation, including promptly complying with reasonable requests for information, really just borrowing a lot of the language from Rule 1.4, and copies of significant documents when necessary to keep the client so informed. And then there's another additional, I think we cover it later, additional requirement to provide the client file at the termination of representation. And they can't withhold it because if in the event the client still owes them money, they still have to provide that document.
Yeah, so again, I prefer your approach here. I will note that the basis for the first language before the alternative language really had to do more with that last point you made, which is the client can get the client file. And so that, I don't want that to be lost, whether it's covered here or separately. I think, at least when Fariba and I were looking at this, and I think the Washington rule, if I remember correctly, was focused on at the client's request, they can obtain their file.
Okay, I'm going to make a note here that we include a cross-reference in to the obligations under Rule 1.16. And we do cross-reference 1.16 for a different point under subparagraph 6, but just informing the client that they have the right to terminate the contract at any time with or without cause and receive a full refund of any unearned fees. And then moving to subparagraph 5, this is really, again, cross-referencing what may be, right now, the duty of confidentiality, I think we've talked about it before, but it's in California, it originated like near the time that we became a state. The legislature passed a statute, which later became 6068E, Business and Profession Code 6068E, which imposes a duty of confidentiality, which is one of the most airtight duties of confidentiality in broad in the United States. So traditionally, the court has not carved out exceptions to that duty before the legislature has done so in our rules of professional conduct, but we do have a parallel rule for the duty of confidentiality. This is one of the things that we're going to need to talk about when we talk about what's required in terms of legislative involvement. The court has the authority, obviously, to impose this duty simply through rulemaking, but we need to decide whether or not we want to break from our tradition in doing that. But to the extent that we don't have a statute yet, and we may have a placeholder here in case a statute is passed, we'll just refer to Rule 1.6. That makes sense.
Yeah, so I agree with all that. Although when you ask about what statutes we might need to stand up the rules, I mean, I do think attorney-client privilege and work product and, in this area of confidentiality are ones where I think there's going to be strong opinions that if a paraprofessional is providing legal services, they should have those attorney-like protections. And I don't know that that's something that can be done by court rule. So that's at least something to think about.
Let me just to be clear. So I would, when we get to this whole listing of the statutes, attorney-client privilege and work product protection definitely, I think, requires some legislative involvement. That's different than the duty of confidentiality, which is broader. So the duty of confidentiality, a duty that's imposed on lawyers beyond just an evidentiary standard, is something that is within the court's power to do. It's just that I'm saying historically, the court has been reticent to get ahead of the legislature in that area. only because of the historical underpinnings of B&P Code 68E. And I have no, I mean, to the extent, so I think when we start putting together our lists of statutes, I wouldn't put this in the absolutely needs to change or we need to adopt. I would probably put it in a second category, which would be probably should have a long and deep discussion with our legislative counterparts about how we want to approach this. Whereas opposed the duty of, I'm sorry, the attorney-client privilege or paraprofessional client privilege is something that I would put in the need to have
Right.
category.
Right. And from my perspective, or at least from the sort of policy question of whether or not there should be a duty of confidentiality for paraprofessionals, I think my answer is it should track what the duty of confidentiality is for attorneys and sort of defer on the best way to get there, right? Yeah.
Yeah. And right now we have really limited exceptions for that duty. Imminent death or bodily harm is really our main exception in the rule itself. So, okay, moving on. So I did already mention subparagraph 6.
So for subparagraph 6, can I ask you a question?
Sure.
So this was a discussion that Fariba and I had, and at least Fariba's understanding was it's not always the case that an attorney can withdraw or quit or be terminated without reason. So this, I think, Fariba felt was important to make clear and might be different than what it is for an attorney. So I just want to make sure we capture it or at least flag it for Fariba.
Okay, yeah. So when we get to Rule 1.16, that's really covered in Rule 1.16, mandatory and permissive withdrawal, and it covers. So this is just making the client understand that the client has an absolute right to terminate the paraprofessional. In terms of the paraprofessional's obligation to terminate representation or ability to representation when it's not mandatory, that's actually covered under Rule 1.16, including having to obtain permission from the tribunal to the extent they're appearing before a tribunal, and it's required. So,
but I think Fariba's point was that the client can't always terminate with or without cause of an attorney. I don't know if that's true or not, but that's where she was coming from in the family law context, that she's had problems with that. So maybe we just flag this for more discussion with Fariba.
Okay. Moving on to 7. Okay, so this is, I just wanted to flag this because we probably need to talk about the financial responsibility rule, and where we need to incorporate that. As right now under the attorney rules, the duty to disclose the lack of malpractice insurance is Rule 1.4.2, and I imagine, first of all, do we want to have also a duty of paraprofessionals, if we're not going to require them to carry malpractice insurance, have the same duty to disclose that they don't have it, and not only at the initiation of representation, but if they had it at the initiation of representation and later their policy lapsed for whatever reason, they have a duty to inform their client at that point. But also what we're contemplating in terms of the surety bond and whether or not the request. So I imagine we're going to have a set of rules, licensing rules, that will be probably under the rules of court. There may be some parallel legislation as well, but at least there'll be a rule of court that sets forth what are the requirements to obtain a license to be a paraprofessional. And I imagine one of those requirements is going to be to maintain the surety bond at the level that we are going to set. If they fail to maintain that surety bond at that level, is there a disciplinable consequence, or is it simply that they, similar to when lawyers fail to meet their mandatory continuing legal education requirement, they're placed on an administrative suspension until they bring themselves in compliance, or when they fail to pay their annual fee? Is it going to be similar to that you're simply placed on an administrative suspension, and you can't practice until you meet that requirement.
Yeah, so I agree, I think, with what you're proposing, which is track the attorney rules for the malpractice side. Again, this is assuming that the full working group agrees with our recommendations and we're moving forward with what we've proposed. But I think that's right, with one exception. If I remember, our discussion was for attorneys, those disclosure rules weren't always very helpful because they could be buried and not effective disclosures. So I would at least hope we could try to make sure, again, with this prominent or whatever we want, but that it is an effective disclosure. So that might be a reason not to track entirely the attorney rules. But again, I defer to what the best way to accomplish that is, to have a effective disclosure. But yeah, for the bond, if there's a bond requirement, I think I don't know if there should be discipline possibilities too, but I think there should be able to suspend practice, or it's sort of a requirement of licensure. So probably the court rules is a better place for that. Again, I think we're going to have a catch-all that any violation of the court rules is also subject to potential discipline or something like that. So I don't know if we need it in both places. But I think it is better placed in the court rules.
Well, I mean, that's a good question if we're going to have a catch-all, because there's, that's interesting. We don't do that for lawyers. So for instance, if you're an out-of-state in-house counsel and you're registered to practice in California because you met the requirements of that rule and you registered with the state bar, if for some reason you are no longer in compliance, I don't think that subjects that lawyer to discipline per se, unless they continue to engage in legal practice after they have been notified that they're out of compliance and on suspension.
Right.
But
what if they don't do a written, what if an attorney does not do a written retention agreement as required by the Business and Professions Code? Is that subject to discipline?
No, as I mentioned at the beginning of the meeting, not unless there's an additional conduct that would be a violation. So if they fail to enter into a written agreement and they lied to a client about their legal obligations, or they were overreaching, or that fee that they charged would be considered unconscionable in some way, so that it would violate our rule 1.5. Just a simple violation of that B&P code, the only consequence would be that the agreement's not enforceable at the option of the client. So
why would we need why would it need to be disciplinable if failure to comply would result in a suspension of the license?
And let me just add on to what you're saying, Leah. We do get a number of discipline cases for attorneys who didn't comply with their MCLE or didn't pay their fee, placed on administrative suspension, and they keep practicing. Now they're in trouble. Now they're going to face discipline. Not because of the original failure to comply with the MCLE requirement, but the fact that they keep practicing after they've been informed that they are no longer authorized to practice.
Right. So in other words, a paraprofessional that does not maintain a bond and does not do MCLE as required, even if those restrictions are in the court rules, if they're practicing without following that, they could still be disciplined.
Yes, and even going further, if they're on administrative suspension for one of those violations or failure to comply with those court rules, and then they abandon their clients, or they start failing to provide services or find, then they may be violating other rules, their duty of competence, duty of communication, because that's a significant development related to representation. Right. If they're no longer authorized to practice. So that they do get into trouble for these things, obviously, and that's when we usually see them in the discipline system.
Well, okay, so I'm fine with this. I agree with the recommendation that the malpractice disclosures should follow the attorney rules, again with the asterisks that we should at least try to remedy the sort of noted problem with the attorney disclosures of malpractice, lack of malpractice insurance, and we'll see what the full working group says about financial responsibility, but that probably belongs in the court rules.
Yeah, so they would have to disclose the fact that they have this obligation, this malpractice insurance obligation, surety bond obligation. And it says, and detailed and clear information about how to file a complaint about the licensed paraprofessional services.
So I'm sorry, where are you? You're on 7?
Paragraph 7.
Yeah.
And I don't know if you want detailed and clear information about how to file a claim against the surety bond.
I mean, I don't know how detailed it needs to be, but I think just some basic information certainly should be included.
Okay.
Should that be its own provision? Like
Well,
it's separate and apart from the malpractice insurance and the surety. Oh, we're talking about how to file a complaint with an insurance carrier or a surety bond agent, not how to file a complaint with the state bar.
Well, this is templated on Washington's rule, so I don't know if it's absolutely clear what it means by complaint. And the reason I flagged this is because we have that rule 1.4.2 that requires a disclosure of that either you carry malpractice insurance, you don't. I mean, for lawyers, it's just the absence of malpractice insurance that needs to be disclosed. But yeah, to your point, Leah, it actually is a separate rule to the extent we're talking about malpractice insurance for lawyers. That's rule 1.4.2. Amos is bringing up the fact that one of the shortcomings that we've identified with that rule for lawyers is that it can be included in a retention agreement, and it's often a provision maybe on page 4. And even, I'll tell you, I was the liaison to the mandatory malpractice insurance working group. And that was one of the potential shortcomings that was identified. Also, the other is a lot of that information isn't really, most clients don't know what that means. You know, they don't know how to process that information really in a way that's actionable in terms of whether or not they are going to decide to engage this lawyer or not. Also, it's coming very late in the process, right? Usually when you're entering into a written agreement, you've already decided to go with this particular lawyer or paraprofessional in this case. And many clients will just go ahead and sign anyway, as opposed to what some states do with lawyers. They identify them on their website as being people that are not carrying malpractice insurance. So
I think we should do that too, by the way. I mean, I think, I don't know that goes in the rules, but I think the bar can publish, you know, when you list the paraprofessionals and their license information, you know, that information can be included. But I think, Leah, is it right that your question has more to do with how to file a complaint about the license?
Yeah, I'm just not, if this language, how to file a complaint about the services is intended to refer to filing a complaint with a malpractice insurance carrier or a surety bond, whatever it's called, agent, then I guess this grouping of these concepts makes sense. But filing a complaint could be just filing a complaint with the state bar about services generally. So then this doesn't make sense. I feel like it would be a separate provision.
Yeah, I see.
That's all I'm saying.
Yeah, and from my perspective, I'm fine with it being a separate provision. I think the intent is if there's a problem with the services, where can the client file a complaint? And that sounds like that's multiple places potentially. The surety bond, the state bar, and if there is malpractice insurance with the insurance carrier.
Great. Yeah, so we'll make that a separate, to the extent we're talking about a complaint with the state bar about a paraprofessional services, this should probably be a separate provision. Would be 8. And then back to the beginning of this, we will still going to have to figure out how to incorporate this alongside rule 1.4.2 to the extent we're going to have a similar rule. It sounds like what you were suggesting, Amos, is that the disclosure about the lack of malpractice insurance should be a separate writing. Is that your position?
I'm sorry, I didn't catch that.
So rule 1.4.2 for lawyers, again, requires disclosure of the absence of malpractice insurance.
Right?
To the extent we're going to have a counterpart for paraprofessionals, do you want that imposed here under this rule? Or do you want it, as lawyers do, have it under a separate rule, 1.4.2? And whether or not you would like to take the additional step of making it a requirement that it be a separate writing.
Oh, got it. Yeah, so I like what you did with 1.4.2. I did take a look at that again with the one note that maybe we can address the concern that it's not necessarily easy to find or it could be buried and needs to be clear. But
Okay.
I don't think it needs a separate writing. I think it just needs to be disclosed in a clear way.
Okay, so then I think if we're going to have a 1.4.2 that's similar to the one for attorneys, and we have the separate rule, I'm sorry, this is just more of like just organizing these rules a little bit. So we're requiring a statement about malpractice insurance here as part of the written agreement, but then we also have that rule 1.4.2 requiring that disclosure. I'm just wondering, should we incorporate the obligations under rule 1.4.2 under this rule?
Yeah.
So that it's all
Cross-reference
in
it.
one place. Okay.
So do you mean cross-reference it? So say, in the written agreement, include the disclosure required by 1.4.2 or something like that?
Something like that. Okay.
I'm open to how you do it. Again, I think the policy decision is, the proposed policy decision is this, similar to attorneys, disclose the lack of malpractice insurance. And, I don't want to create duplicative rules,
Right.
but I think it makes sense to do it this way, to have it here and cross-reference the 1.4.2. Maybe this is where we can fix it, that it needs to be clear and conspicuous or something like that. So you don't have 1.4.2 being different for attorneys and paraprofessionals. You have this specific paraprofessional rule making clear it needs to be, in a disclosed in a meaningful way.
Okay. Yeah.
Say.
And that actually makes sense to do it that way because the 1.4.2 requires that disclosure, not just at the initiation of representation, but it's an ongoing obligation throughout representation as well. So it makes
Right.
sense to cross-reference in here.
Can I ask if we would want to require the disclosure to be on the home page of the website?
You know what's going to happen when you make that that. I mean, just so you know, there'll be significant opposition just because there's a number of lawyers that are concerned about changing the obligations for lawyers.
I know.
But that's not to say that that's not, again, the one thing about the mandatory malpractice insurance working group, no recommendations ever came to the court from that group other than they did their work and then issued a report. So it would be, if to the extent we want to impose higher level of disclosure obligations on paraprofessionals, I think that's fully within the purview of this working group to do. And if that later on affects the obligations for lawyers, then we can take that up as that happens. So
yeah,
the other issue about a disclosure of lack of insurance, or even just a disclosure on the website that the person is insured. The problem with that is the fact of malpractice insurance being on a claims-made basis.
Right.
So if someone hires an attorney and they're insured at the time that they hired them, they might not be insured at the time a claim is made. And I think that is a concern that was raised even in places where such a disclosure is on the website. It might be somewhat misleading to people.
Yeah, exactly. That's another shortcoming. Mm-hmm.
Yeah, although the fact that they don't have malpractice insurance is still a relevant factor for a client to consider, even if it's possible they later get insurance. I think the decision point is intended to be when you're making the decision to hire this person, is it important that they're licensed? Is it important that they're bonded? Is it important that they have professional liability insurance? So, but I agree, it's tricky and probably wouldn't fit here in the rules anyway. Probably this isn't in the written disclosure requirement. That would be in the advertising rules.
Yeah, that's why I was saying that when you were talking about where it should go, if we wanted to do something about the website, which I think it could simply be, you must put on your website if you don't have it, then you kind of get out of that issue of I put on my website that I do have it, but it doesn't actually mean anything. Um, um, then I think that wouldn't go here. That's why it just triggered my thinking around that.
Right.
So-
Yeah, I agree. Although it seems like it might be controversial to even require license number or or name or address. So obviously, I'm of the opinion the more disclosure the better. But and that is a relevant fact. I would love to see disclosed, but I don't know about the website stuff.
Okay, we can move on. Just make a little note of it in case we want to come back to it ever.
Okay. What I have now is 9 because I created a new paragraph for the complaint filing process, but it's 8. A statement about the respective responsibilities. Again, I borrowed this from the Business and Profession Code provision, and this really parallels, the allocation of authority similar to between lawyers and their clients. The client really controls setting the objectives of representation, whereas the attorney retains professional independence, independent judgment in terms of employing the means for achieving those goals. So this is another area where I think it would be helpful to provide a statement in a templated form for paraprofessionals so that they could.
So I really like this, and I think this was a Greg edition, right? This wasn't in the rules that I drafted or that I talked with Friba or that are in Washington. And I think one reason might be that at least in Washington, the representation isn't the same as an attorney, right? It's more help filling out forms. So I like this, and I like that it tracks the Business and Profession Code. But I do think, again, an asterisk here, because we probably need to discuss, like, if is this really representation? Like, if talking to the opposing party, only the paraprofessional is going to do that, not the client. And so, responsibilities between them. I think there's sort of some underlying assumptions here. And I just don't know what the answer is.
Yeah. Yeah. What those responsibilities are. Yeah. It's going to definitely be informed by what activities are going to be permissible. There certainly will be a division of responsibilities between the client and the paraprofessional to some extent. So the most common one that I can think of is the client actually providing the required information for the paraprofessional to do their job. And, as an attorney, former practicing attorney, it's not always an easy lift with some clients. So
that's right. And it's a standard paragraph or two in every retention letter that I've ever seen, and often important, especially if there's problems.
Right. And then I have just the catch-all that there may be additional disclosures that are imposed either through these rules, and then in the comments we may just keep a list of any additional obligations that they need to make sure that they include, because depending on the type of representation we're talking about, there may be other requirements to provide informed consent. For instance, if there's certain conflicts of interest where it's permissible to have an ethical screening process, or that may be something that needs to be covered in that written agreement as well.
That's great.
Okay, and then moving on to B. So I think B1, this is really tracking the informed written. I wrote written consent and the preferred language about the risks and alternatives of obtaining legal services from a licensed paraprofessional. So again,
sorry to interrupt, but before we go on to informed consent, I noticed that on the rules that we had, the draft rules, you just incorporate for the written agreement. That was all 2A through I, but I think you did not include paragraphs 3 and 4. And I just want to make sure that's intentional.
Let me see. I need to pull up. Let me pull up your. Do you happen to remember that the way I organized this, around the date that you had sent out those agreements? I mean, those provisions.
Well, is it Linda? Maybe she can share it again. Is it in what she was just sharing?
Well, I
Yeah,
don't want her to take away though what we're looking at because we're kind
if
of
you just scroll down.
Yeah,
So
I
you
don't.
know,
I think
I
it was in
don't yet know
November.
how to do a split screen on this.
I found it. They were distributed for the December 1st meeting. So let me go to the informed consent. Okay.
So it's actually on the written agreement one.
Oh, it's on the written agreement one? Okay.
Yeah, you included number 1 in the comment to 5.5, number 2, A through I is what we just went over, but we haven't talked about 3 and 4.
Oh, and I think I may have talked about this in my memo.
Yeah.
Right. So let's go to my memo real quick. Okay. I said, I think paragraph 3 under written agreement and mandatory disclosures is repetitive of rules 1.16 and 5.5. So I propose that they be eliminated. And what I meant there was, so 3 again said, a paraprofessional may not provide services that exceed the scope of practice authorized by this rule and shall inform the client in such instance when the client should seek services of a lawyer. Right. So that is squarely covered under 5.5. To the extent, and when we talk about 5.5, because the way that 5.5 reads for lawyers, I think we're going to have to do some significant revisions to it for paraprofessionals because of the limited authorized scope of practice. Right. So a lawyer doesn't violate UPL simply by working on a will when they're a family law practitioner, because we're, as Professor Sandefur likes to say, omnicompetent to do anything as long as we obtain the skill and knowledge to do so. So I think we need to revise 5.5, and I provided some revisions to that, I think, in the set of rules that you have. And I think that's adequately covered here. This is not something that, according to this rule, it's not something that is even envisioned as being part of the written agreement.
That's right. So but it's a 2-part. So I just want to make sure they're both covered in 5.5,
Okay.
or at least we cover it. One is that they can't provide the services, and the other is that they'll inform the client. So that's why it's in this disclosure.
Yes, and I think that the requirement to inform the client is also covered. What did I say in the memo? I think it's really covered under the rules of communication. So 1.16. So not the rules of communication. It's actually the declining and terminating representation. So if we go to my revisions to 1.16. Okay, so can you guys pull up my red line of the rules of professional conduct?
Linda, can you let me screen share?
And slide down to 1.16.
Oh, it's way down.
There you go. So under A8, there's a new A5. This has no parallel to the attorney's rules. So the introductory paragraph says, except under C, a licensed paraprofessional shall not represent a client, or where representation has commenced, shall withdraw from representation of a client if, and 5 says, the licensed paraprofessional knows or reasonably should know the subject of representation is beyond the scope of the defined practice area for which the licensed paraprofessional is licensed as set forth. And then we're going to have a cross-reference to that particular rule that sets forth the scope of permissible practice, which may, I think, actually be a rule of court. where we have the, the requirements for each endorsement, as well as what, once licensed, what are you permitted to do and not do. If the subject of representation is beyond the scope of the licensed paraprofessional's defined practice area, the licensed paraprofessional shall not render any legal assistance and shall not advise a client to seek, and shall advise a client to seek the services of a lawyer or licensed paraprofessional authorized to provide legal services on the subject of representation. So I think that's probably a better place to deal with that than to put it in the written agreement, because it's not something we're envisioning that would be in the written agreement, but it is an affirmative obligation. And it also doesn't prevent the paraprofessional from, so if they're providing family law services and then suddenly the client wants them to do something that's beyond the scope of a family law paraprofessional, that doesn't mean they need to terminate the representation with regard to that subject matter of the representation, but they need to actually refer them out and do not provide services in that area. So this would be what we consider to be a mandatory withdrawal, to the extent that they want to expand the scope of that representation to include that. So does that make sense?
Yeah,
Okay.
yeah, that works. Again, my only concern is the spreading out of these things, but yeah, I think this is the better, more appropriate place for it. And this
Right. And so if we go back to written agreement, it may be that we want to put a cross-reference to that provision then, so that it's clear. Yeah, we may want to put in a disclosure, Amos, like you're referring to, that says when they're talking about the explanation of the services to be performed, perhaps something to the extent, to the effect that, to the extent that a client wishes to engage the paraprofessional, I mean, we have to wordsmith it now, but to engage them in services beyond the scope, they should inform them that they are obligated to decline and refer out.
Right. That's exactly what I have in mind, except again, without being too repetitive and having it in different places. So again, I defer to you, but that it looks like 1.16 A5 really captures.
Yeah, and 1.16, we do this a lot in these rules. There's an obligation that you have, and then there's an obligation to disclose that you have this obligation, right? So this would be one of the obligations of disclosure that, hey, I'm constrained in what I can and cannot do. And this is one of the significant constraints that I have that may affect you in some way. So I just want to let you know early on about this constraint. And if it pops up later, you'll hear from me. I'll tell you, I can't do that, but here are 3 attorneys and maybe 3 paraprofessionals that may be able to provide you services in that area, but I can't do it myself.
Exactly. And at least when Fariba and I were going through this initially, we decided that that was a significant enough required disclosure that we wanted to make it clear. That may or may not be the same for attorneys, but given the limited scope being contemplated, that should be clearly disclosed, and maybe even fall within the risks of hiring a paraprofessional instead of an attorney. But whether that is true or not, it's probably something that should be disclosed. Limited license, these are the areas I can practice, these are the areas I can't. Type disclosure. Okay, perfect. And how about 4?
4, substance of, oh yeah, I didn't say that. So document prepare. Did I not? Yeah, we should probably, I'm sorry if I didn't incorporate that. So
this might be something we discussed, but at least initially Fariba and I discussed that a paraprofessional should be signing documents. What's that?
Is this any document, like any pleading that's filed with a tribunal, or?
So again, Fariba and I were still, we don't want to get ahead of what the working group's deciding, but I think we were thinking that, just like attorneys can ghostwrite documents, I guess, and have, fill them out for our client to file in pro per. I don't know if technically that's allowed or not, but I think if the idea was we should be expressed, if paraprofessionals are are anticipated to fill out court forms and sign them as the representative, then they should provide their name and license number. Again, maybe that's something the working group will decide they don't want to do. Everything's going to be improper, but my sense is the way everything's leaning is we'll want to address this in some way.
Yeah, and I think that this might, rather than addressing it in this particular rule, because again, I think this is beyond the scope of what's required in the written agreement or informed consent, but it may be something that we want to incorporate in the communication rules, that's the Series 7 rules around what gets communicated through not just advertising, but any communication that's sent out. But this also covers pleadings and I need to think about this. I'm sorry that I actually must have
Wouldn't
missed.
it go in scope of practice?
Yeah, that's what I was thinking as well, that it's something that's required anytime they're filing anything.
Yeah, we should be careful because I think maybe it should be appropriate to file, hire limited service paraprofessional, just assist with some things and not take on representation. So not necessarily appear on the pleadings. I don't know. It's a difficult question because I can see how, like in family law, you might not be hiring a paraprofessional for everything the paraprofessional can do, but you need assistance on, some motion. So either that's going to be a limited appearance or they can behind the scenes help you. We haven't worked through that issue anyway.
Yeah, and so this is a disclosure really not to benefit the client, but really to benefit the tribunal, so they know who is actually filing things in the court.
And there is something similar, I think, on UD forms. I've seen something for UD paraprofessionals, or I should say UD assistants. Currently, I haven't seen it used much, but I've seen it on the form. And we should at least, again, I don't know where it goes, but something that, is it appropriate for a paraprofessional to sign and file court forms like an attorney would?
Yeah, I think Leah may be right that, we may want to cross-reference this in the general communication rules, so they're not misrepresenting who actually prepared the document. But I think this is also really a scope of practice rule that might be in the rules of court. But we should flag that, and I'll do some more thinking around that as well. Okay, so should we move on to the informed consent?
Yeah, sorry about the digression.
Okay. Okay, so the informed consent, again, I guess if we're going to say that this all can be one document, we should note that in the comments. We did that in a couple places in the rules of professional conduct for attorneys. The malpractice disclosure is the one that leaps to mind immediately. But we would have a comment similar to that one, which says, oops.
Okay, but just to be clear, I do not think these two things can be the same document.
Oh, okay. I wasn't sure about that because I thought you said earlier that they should be the same document. Well, then we should have a comment that makes that clear as well.
Right.
That it should be a separate.
At least, again, subject to comment, and this is all still recommendations for the full working group, but the idea is the informed consent requirement is separate from the written agreement requirement.
Okay.
Although it sounds like we're leaning towards having the informed consent requirement in writing.
I mean, I just was trying to indicate that that's really our preference in California. There's a few areas I can send you an email of the different areas in which we don't require writing, so you can see, and then there's a policy reason behind it, and I can provide you that rationale as well.
Yeah, I tried to look as I was putting this informed consent language together, because there isn't something that there isn't a similar Washington model, so I wasn't pulling it from there. And I tried to look up, so I did see, I think in the medical area, I don't think it's required to be in consent, but again, doctors often find it appropriate to have something.
Yeah, it's usually a best practice.
Yeah.
Yeah. Okay, so this informed consent would be a separate document. Again, we're saying the paraprofessional must disclose that they are not a lawyer. So it's a disclosure that's going to be required in both writings. Is that correct? And then we are saying number B2, reasonable disclosure of available choices, including availability of a lawyer as an alternative. I guess I have a comment here is whether or not that's always going to be the case. Because we've talked about this in the past that for some people, it's not really a choice between paraprofessional and lawyer. It's choice between paraprofessional and no representation at all, especially for somebody who just cannot obtain a lawyer.
We also received public comment from, now I forget, sorry, but I thought very helpful comments, both from the Stanton professor and the other person who was from the, sorry, I have his letter right here, but that we shouldn't necessarily speak in the negative.
Yeah.
I'll just paraphrase his comment, which I think is well taken, that this is an informed consent requirement. So it is about disclosing the risks and making sure it's an informed decision, but it's not necessarily saying one is better than the other for any particular situation. So I think we should be mindful of that. And I'm happy to have us revise this language to support the paraprofessional and not necessarily make it a second-class citizen. But again, the idea is informed consent. It requires somebody to understand what it means to hire a paraprofessional as opposed to hiring a lawyer, and whatever risks or limitations that brings with it.
And I guess I alluded to that in 3 when it talks about the risks of agreeing to obtaining legal services from the paraprofessional. We should probably provide a predefined set of risks that everyone can agree to, as well as perhaps benefits of obtaining services from a paraprofessional, as opposed to either having no representation or even the representation of an attorney. To the extent that we do agree to statutory fee caps, that's one of the benefits, is potentially lower cost for the client. Back to 2, I don't know how to approach this, because again, I'm not sure we can, we wouldn't necessarily be misleading the client into believing that there's the availability of free consultation with a lawyer in every circumstance, or that there may be available limited scope services. I think we probably would want to talk about this in more of the sense that there potentially may be these available choices, but not necessarily that guaranteeing that these are alternatives that are available.
Yeah, so I'm with you. If we can come up, and I'm happy to try to think about this, or maybe we each do it independently and come together. I'm happy to try to revise this. The idea is, I think, as you're saying, we probably need more detail here, not less, or provide a sample form so that people can do a good job with informed consent. We don't want to be too vague.
Right.
With that being said, I think I don't know that there's a standard language that will apply in every case. In other words, if somebody's getting assistance in child custody and support matters, that may look very different than what the risks are in connection with, filing some other family court motion or in some other case type. So I just don't know if there is sort of boilerplate language for every disclosure in every case, or it really depends on what the legal issue is and what the circumstances are.
Which I guess brings me back to my earlier point, which is it makes it more difficult to define this as a disciplinary standard at this point then, because it is so variable. And I think a number of paraprofessionals may complain later to the extent they're being disciplined for violating that provision. I did the best I could trying to disclose risks.
And in terms of about other services available, are you imposing a requirement on paraprofessionals to always be up to date on the different types of services that might be available? Because that changes even within a community and for a specific practice area.
That's right. Yeah.
And I don't know if it's reasonable to expect paraprofessionals to be up to date on that day to day.
Yeah, and so this is where I think we need your help, because I think it's very clear we want an informed consent requirement. I think it's relatively clear what an informed consent requirement is or should require, but I don't know if we can have boilerplate language that is, if you just plug in this boilerplate language, that's sufficient or not. But the idea is currently there is no informed consent requirement for lawyers. So this is something that we are creating, and that the ADLS group suggested we create, and that Fariba and I agree it makes sense to have an informed consent requirement. But what exactly this language is, I think we kind of need your help in sort of figuring it out. I think this list is pretty good. And I'd be satisfied with it, but we certainly can wordsmith the language or decide if things are missing or that sort of thing. But if you have different ideas for how we can put meat on the bones of an informed consent requirement, I think we're definitely flexible.
Two different thoughts. One is that the informed consent is not necessarily around what other options there are, but it's a clear understanding of what the paraprofessional can and cannot do, the scope of practice. That's what you're consenting to. So I have one thought. And then my other one is something simpler rather than more detailed, like a reasonable disclosure of options. Your options include lawyers who may take your entire case or part of your case, and free legal like paid lawyers who may take all or part of your case, or free legal services if you qualify, period. So presenting them as options that may exist, but I kind of tend towards why is part of the disclosure telling you about your options instead of we're being super clear about what I as the paraprofessional can actually do and can't.
Yeah, so I think that's a great point. I definitely think what you're saying needs to be part of it, but I also definitely think it can't be the extent of it. The idea is that informed consent is information about the risks and the alternatives. It's not informed consent if you're just told, I can file this for you, hire me, I'll do it, and you don't know the risks and the alternatives. And so I would say the more important part of informed consent, obviously the paraprofessional is going to, in one way or another, through advertisement or through initial consultation, inform the client about what their proposed services are, and maybe even what they can and can't do. But the informed consent, I think the important part of it is that they understand the risks and the alternatives. And otherwise, I don't think we should call it an informed consent if it doesn't include risks and alternatives.
So just to kind of tease this out a little bit, what do you, Amos, what do you see as being the major risks for clients engaging a paraprofessional, assuming that they are engaging them to provide services and within the scope of their license?
Yeah, I mean, I have two answers to that, because this regulation subcommittee, part of its charge is, I think, to identify the risks and propose some regulation. So I think the risks that we've identified that we might want to regulate towards might be slightly different than the risks I'll say in response to your question, which I think a big part of it is, that the scope isn't going to be enough, right? Either the legal matter has other aspects to it that go beyond what's either allowed within the practice for the paraprofessional, or might quickly go beyond, or the competence of the paraprofessional, right? So if it's like, I need help with this aspect of the hearing. Let's say there's a child custody and support issue. I'm not a family lawyer, but I assume a paraprofessional will be able to collect the information, draft some sort of motion or opposition. But depending on what the restrictions are, we don't know if they're going to be able to attend the hearing and argue at the hearing, and maybe they really need somebody who can attend the hearing and argue at the hearing. All right. I personally think a big risk is the cost. Again, that's something that we haven't yet decided. if there were strict rules and regulations about the cost, I'd feel more comfortable, but otherwise it might be that they end up paying just as much or more hiring a paraprofessional than an attorney. So it depends what we regulate, but that is another risk. In the housing context for UDs, if again, assuming that a paraprofessional can file an answer, maybe do some discovery, but can't handle a jury trial, it might be that they can hire a paraprofessional now, but assuming it doesn't settle or go away, they might need to hire an attorney later. So again, I think, and there might be others, but again, I think I agree with Leah that part of it is disclosure of just what the rules are. I can do this and I can't do that, but part of it is, in your situation, there's a risk that you're going to hire me and have to get an attorney, or hire me and I won't be able to fully represent you, and instead you could hire an attorney, or a free attorney might be available. Again, that's been a comment from legal services is, for some of the population, there may be free legal services available, and that should be part of the disclosures.
Yeah. And under 4, we have the potential need to hire a lawyer or another paraprofessional if needed services go beyond the limited license of the licensed paraprofessional. So it seems that your first and third point is sort of covered. We may want to change the language a little bit. In terms of the financial aspect, I think what Linda had alluded to, I think in a broader sense, or it may have been Leah, that there may be free legal services available depending on your eligibility. Something a little more general rather than obligating them to provide a list of organizations that you can follow up with, unless we're providing that to them, because it's going to perhaps be beyond the scope of any obligation we want to impose on them to keep tabs on which legal services organizations are offering similar services. And so it seems that would cover most of what you're saying. And then in terms of spending more, well, if you can get free legal services, hopefully that disclosure will help in some way. But in terms of entering the written agreement and providing, this is the basis for costs and fees, if you agree to go with this paraprofessional, that they're provided that information. Maybe what you're asking us to do is, or asking the paraprofessional to do early on in this informed consent phase, before we get to the written agreement, is provide more information about how their fees work and any restrictions they have on their ability to charge certain fees.
So I think all that is fair, and it might be that we can either combine some of these different points, or either combine them or separate them more. I agree. I don't think we should require paraprofessionals to have like a list of referrals that they're providing, that instead of hiring me, here's all the other people you could hire. I don't think that's appropriate, necessary. But yes, for the fee, I don't know exactly how to get there, but that is exactly the concern, that if it is true that the paraprofessional doesn't have fee caps or their schedule, and they can charge sort of whatever the market will bear, the fact that you can get an attorney for cheaper is probably relevant information that the client needs to have to make an informed choice, right? I think that would be fair to say there's an attorney next door that doesn't have these same restrictions and provides these services at a flat rate of $800. My fees are likely to be $2,000. I think that would be important to disclose to the potential client.
It would be important for the client to know that. I wonder if at that, well, we'll have to see, because each of those, so for family law, if we've been talking about debt collection recently in some of these subcommittee meetings, and lawyers can charge contingency fees. So the clients are really not out of pocket for anything. But when it comes to family law, to the extent they're retaining a lawyer, they will be paying probably hourly fees. So that open-endedness of hiring a lawyer is similar to the way it could be for paraprofessional. So
Yeah.
the disclosure may have to take that into account as well. Because
guess-
there may be, go ahead.
I'm just struggling with this because how is the paraprofessional going to know that I'm going to charge you $2,000, but this lawyer next door to me is only going to charge you $800, because we don't require lawyers to disclose their fees. So I don't know how I'm going to be in a position to know this. And I guess I just feel like it's sort of fundamentally problematic, because I could just be really a lawyer. Okay, we're 4 lawyers on this screen, or however many we're seeing. And I could be a horrible lawyer. I could have no idea. I've never taken a family law case, or I've been disciplined before, or I just never paid attention in law school and I really hate my job. And I'm going to charge you a lot more than Greg, who's amazing and a family law specialist. And I happen to know he charges less than me, but I'm not required to tell you that. If you come to me and want to hire me, I don't have to say, well, I'm really not very good. And there's this other guy who's really good and he's going to charge you less than I'm charging you. So I just feel like this is starting to be
Well, that's why I feel like,
problematic.
that's why I feel like the disclosure has to be couched in these terms that, there may be a lawyer available as an alternative, and they may provide free consultation to you, because the paraprofessional is not going to be in a position, like you're saying, Leah, may not be in a position to know whether or not that's true or not. And I'd hate for the paraprofessional to be in a position where it sounds like they're giving a guarantee, hey, you can go out and get a free consultation from a lawyer, when the fact may be that they can't.
Right.
Um,
I'm totally fine with that. But I think for an informed consent requirement to be meaningful, it can't just be, here's what I'm going to do for you. Here's what the rules allow me to do for you, and here's what I'm going to do for you. Because that's not informed consent. That does not provide information that the potential client needs to make the decision of whether this is a good fit for them. Obviously they need legal services. That's not the question. The question is, does it make sense to hire this paraprofessional as opposed to the alternatives? In light of the cost, and in light of the restrictions, and in light of other services that might be available.
As you're talking, I'm wondering if the requirement is really on the state bar. Like, as part of promulgating a new class of licensees, is there a requirement to make sure that the consumer knows what this licensee can and cannot do, and what other options there are? And could the requirement even be that the state bar puts out like an FAQ kind of document, for lack of a better term, and the paraprofessional is required to provide that FAQ. In fact, it could be the lawyers are required to provide it too, because wouldn't we want lawyers to have to tell their clients, you may qualify for free legal services. Hey, you're hiring me, but you may qualify for legal aid. That's what I'm almost wondering. Like, we have a responsibility to the public and to protect consumers. We have to produce something, and then maybe paraprofessionals and lawyers have to hand it out.
Yeah, so I think it's a great point. Again, I think that's separate from informed consent, and I think it was specifically recommended by the ADL's task force as well. So informed consent is something that the paraprofessional has to provide information to the client for them to make an informed decision of whether to make that specific engagement in that specific circumstance. So that is different. But I do think consumer understanding and outreach with a separate bullet point of key recommendations from ADLs that I definitely think it included determining the appropriate name for the new providers, consideration of mandatory disclosures and possible informed consent requirement, and regulators' responsibility to educate the public regarding the availability and authority of the new class of licensees. And I think it's a really good point, because I think the state bar probably can do a lot to help inform the public of this new licensee and what they're allowed to do and not allowed to do. And I think that would be very helpful, but I don't think that takes the place of an informed consent requirement.
Well, I mean, if the state bar is going to take on that obligation, maybe this could be something that is in the agreement, the informed consent agreement refers to a particular page on the state bar's website that provides that information.
Absolutely.
If the state bar is going to maintain a list of potential free legal services in different regions, the paraprofessional could just refer to this page, and the page would become a living, breathing document that gets updated by the state bar.
I think that would be great. Again, I think our task on the regulation subcommittee isn't necessarily to tell the bar what websites to design and what information to provide, but I think that would be a terrific service, and I think it would really help educate the public. And I agree, it could be cross-referenced in the informed consent document. I think that would be great.
And Greg, just to clarify, I wasn't actually suggesting there'd be this page with all of your options, like to getting down to the name of programs. I think that would be very difficult to maintain, actually. I mean, for example, we know all of the IOLTA, all the legal services programs that we fund, but there are other programs. I was simply referring to something a bit at the higher level up, saying there are, you have options as a consumer seeking legal services. You may be eligible for free legal services, you know, you may be eligible for a free consult from a lawyer at that level rather than the granular.
Right. And actually, that's what I was referring to earlier, that just make this more of a disclosure. These may be things that are available to you rather than providing any sort of guarantee that these things would be available. Make it a more general statement.
I agree, although I do think though it's well within the bar's ability to provide a more fulsome directory of legal services available in California. Obviously it has to do with funding issues and issues well beyond this committee. But I think that could be a very helpful resource, especially when linked to this. It says there may be resources available to you and link to the bar's page, or I think there's now a private attempt to do that, but I think the bar could probably do it much better.
I think just to finish up this rule, again, if we're imagining that these are, if this could be the informed consent and written agreement could be contained within one document, then B1, I think B4 and B6 probably are redundant to what's required under paragraph A. That was the final point I was making in my memo. The disclosure that I'm not, the paraprofessional is not a lawyer, that there may be the potential for, and this is actually B4, Amos, is where we could refer to that new provision under Rule 116. There may be a potential need for the client to hire a lawyer or another paraprofessional to the extent the services needed go beyond the scope of the paraprofessional's license. And then B6, reasonable estimate. If it's one writing, we've already provided for that under the written agreement.
Right, and it looks like in our draft rules language, you didn't include number 2 or number 3. I think in your memo you said number 3 is not needed. Let me look at number 2.
Under informed consent?
Informed consent.
Yeah, I think 2 may provide additional information, guidance on the requirements of conforms. This would probably be, this is more suited to being a comment.
Right.
Anytime I see the word may, it's not a strict standard. So this may be something that we put into a comment.
Right, and this also looks like it covers what you were just discussing or recommending, that there might be a standard form,
right,
or links to the bar website, or these are, I think, ways we can make this more effective, but I don't know, I agree, it might not be appropriate for the rule itself.
And to the extent that the paraprofessional board is going to require additional disclosures, that's what I think what we're trying to achieve under A10. Any disclosure statements or conditions required by the paraprofessional board.
Right.
So I think that brings us to the end of this one. That may be a place for us to stop since it's 3:57 before we go into technical practice.
Can I ask 2 things? One, in terms of thinking about the April meeting and issues to tee up, I think informed consent is going to be a very significant policy issue and discussion for the group. unless Amos, you're thinking we're going to have that discussion when we meet this week. The Joint Regulation and Discipline Committee.
I'm not sure I understand. So you're talking about.
Well, I'm just,
informed
all
consent
I'm
separate-
saying is I'm thinking about what's going to take up a lot of our time as a working group. And I think the issue of informed consent is that what we mean by it, just this conversation we've had today. So I'm thinking about how we want to structure our overall discussion about draft rules, and just thinking about what's going to take more and less time. I'm thinking about what was the most difficult for us to tackle today. It's really that one that we did at the end.
And the April meeting is the one where we're going to plan on going through all these rules, these draft rules. Got it. Yeah, I mean, frankly, I think the fees, which we skipped today, sorry about that. I think the fees are the difficult one. I don't know that informed consent, at least when we described it last time, so maybe 2 or 3 working group meetings ago when we presented, my sense was the informed consent wasn't controversial, and the requirement that it be in writing wasn't controversial. I think, I don't know that we dug deep enough to know whether people were thinking of 1 writing versus 2, but my sense was the informed consent requirement was not that controversial, but I might obviously be wrong.
Yeah, I think it gets very tricky once you start trying to specify what the language is.
That's fair.
Just what we're doing.
That's fair. Yeah. So I'm worried about the fee discussion, but we probably still need to prepare a little bit, and I'd love to have Fariba here for that.
Yeah.
And the fee
and the advertising. We haven't gotten to the advertising.
You haven't gotten to advertising, and the fee discussion is really 2 things. It's well, there's probably more than 2, but the discussion around fee caps, which I think will be a long discussion, and then also referral fees, which will
exactly
also be a long discussion.
I feel like we haven't tackled those yet, and so if we can't get through it, imagine the full working group, right?
Yeah.
So Linda, I'm just looking at when the next meeting of just this group is. It's on the 23rd. Okay. So I just want to make sure we have enough meetings before the big meeting on the 19th.
Yeah.
To get through the rest of these issues, and I think we only have 2 more. The 23rd and the 30th.
And maybe we can go quicker. I'm sorry if I slowed down your progress, Greg. I think you made terrific progress in your draft rules and memo.
I think that's fine, Amos. I think scope of practice and prohibited acts, I think we can go through that pretty quickly. A lot of that is covered under pre-existing rules. I hope we can go through that pretty quickly. Fee language we can discuss as well. The actual fee rule, I don't think is going to be that controversial. We have to decide between unreasonable and unconscionable. But I'm not sure the fee caps is part of that discussion in terms of the rules of professional conduct. I think fee caps will probably be imposed in some other area. And then we need to backtrack to finish up the policy discussions around firms. And then I also wanted to introduce the idea of whether or not there'll be a restriction on paraprofessionals representing organizations.
Right.
And then there's probably, just going through the rules are probably some other issues that we're not quite seeing yet that as you go through the rules may pop up that we'll have to focus on.
So I think I agree. And I think that means we probably need more meetings, because I mean, even just going through the stuff that you sent that we didn't cover, I have some quite, it's because they didn't come up as large policy issues, but it comes up as you're drafting the rules. And I don't know if you have a preference, but I think it might be better for us to discuss them preliminarily in this subcommittee before they're presented to the full working group. Again, I don't have a strong preference for that. I'm more focused on the issues that we've sort of raised are particular to paraprofessionals, but it seems like there's a lot of things to potentially discuss.
In terms, I know we're out of time now, but maybe next time we can also talk about how we're going to approach that April meeting.
Okay, so I think we'll send out a little doodle or something to get 1 more meeting scheduled, maybe that first week of April. And And then Greg, maybe you can think about, or we could talk about how to structure these meetings so we just make sure we get through everything we have outstanding. If we have 3 more meetings before April 19th.
I think Carolyn Shining has her hand up right now, but.
Oh, okay. I thought I haven't seen that. Let me stop this.
Well, it's down now.
I think she had it up for a while. She wanted us to send her your memo, but we did.
Okay.
Yeah.
All right, good.
And we also have this meeting that's starting in about 1 minute.
Okay.
Leah.
Good here.
So
Do we need to talk anything
and
about
she-
the presentation on Thursday, or maybe I'll reach out to Fariba about that?
Yeah, I think remember, we just didn't get to you guys last time. So I wasn't planning on anything different. We have the PowerPoint that the slides that we never got to. And yeah.
Hopefully it'll go smooth.
Yeah.
Are we done with speakers for this group? Are we focused on the rules drafting, or do we want to hear more speakers about, I think, fee issues in particular, but also other regulations?
Well, maybe we can decide that next time if you want to hear speakers. I wasn't planning on trying to get any more speakers because I feel like we have a lot of heavy lifting work to do in these meetings.
I think that's right, although a couple ideas came up in some of the others, so I can email you about that. And I think we have plenty of work to do, so.
Yeah.
Okay.
All right. Thank you, guys.
Thank you, everyone. Especially
Bye.
Ken, thank you very much.
All right. Bye.